Generally, people who are attending this, they have questions. And I find it to be beneficial because if one person has the question, more than likely the other attendees are in the same boat and tend to have the same questions. So please, please, please feel free to ask questions. Um, and then a lot of what happens then is I can kind of give you the education and the background surrounding um, the information you're looking for while answering the question. Um, so I think that's a good route. So does everybody know how to go about asking questions here? Um,
Yeah, you can absolutely, you can put it in the chat. I can see that. There is also a Q&A feature that does keep it a little bit nicer. And I can kind of keep track of it better. But if you can't access the Q&A for some reason, or the chat's easier, that's fine. Or go ahead and there's like a little hand feature. And yes, people are saying yes. So I think they
okay.
know. Yeah.
Okay,
But
good.
you can also use that.
Okay. Okay. And give me a heads up if there's a question and I'm not
Yes.
seeing it because on
Yep.
my screen, I'm not sure where the bar is going to be, where the question is.
That's
So,
fine. I will give you a little wave and
okay.
stop you.
Okay, good. Thank you. Thank you. Um, so generally, I'm thinking my audience here are people who have beneficiaries, children, loved ones, who they want to remember in their uh, testamentary plan. You know, they want to uh, leave assets to these people who may have disabilities, different special needs. So, one thing that you need to think about is most people that have special needs will oftentimes either need governmental benefits or are already on governmental benefits or may eventually need to qualify for governmental benefits. So any money left to these individuals could really disrupt their ability to maintain whatever benefits they have now, um, or preclude them from needing from receiving them sometime in the future. Um, I get a lot of people in who they don't really think about, oh, wait a second, what's going to happen when I die? Um, they're very much taking care of their kids, and that's what people do. They just take care of their kids. They pay for things for these kids. As time goes on, they continue to pay for them. Um, and that may not always be the best route to take. So, um, as we think through things, we don't want, you need to be cognizant of what your estate plan is so that when you do pass away, your assets are not going to be allocated to that child um, individually and outright. So, as people go through their estate planning, when they come in, I kind of get a very general idea of, okay, if you were to die next week, where do you want your assets to go? Who do you want to reap the benefit of these assets? Um, and oftentimes people tell me to my kids, equally to my kids, but I'll often hear, well, I've got 4 kids, but I only wanted to go to 3 because I don't want to screw up the benefits of my 4th one who's got special needs. Um, and really what I try and figure out is, well, is the only reason you're not allocating anything to that child because you don't want to screw up their benefits? Or is there, and if that's the case, then I can give you a mechanism to to allocate funds to them without screwing up their benefits. So I really try and discern what the estate planning goals are right off the bat. Um, some people will come in and say, I want everything going to my one child that has special needs. And, the rest of my kids, I'm not going to give them anything. we kind of talk through that as well, because oftentimes there are kids that have special needs that are getting great benefits, and they're really getting them in a good position, that they don't need a whole lot of money. So I try and talk that through with people. What are your disabled child's needs? How are they being met now? And do they really need as much as maybe what your other kids need? You know, one child may have five kids of their own, and they're not disabled, but they could really use some benefits, or use some assets from you. Uh, and you don't necessarily want to cut them out because you feel like all assets should go to my child that has the special needs. So we kind of talk through that kind of thing. Generally speaking, when somebody has a beneficiary with special needs, my go-to planning tool is a wholly discretionary trust. That's WDT is the acronym. Wholly is spelled WHOLLY. And it's a trust that is, it's a statutory trust in Ohio, very well established, that if your disabled child is the beneficiary of a wholly discretionary trust, the assets in that trust will not be counted as their assets in determining whether or not they qualify for governmental benefits, any needs-based benefits. And we should kind of go into what are the needs-based benefits. Needs-based benefits, generally, when people are thinking through this, we're talking about Social Security, which is what funds, monthly income they can get each month, and Medicare and Medicaid, and that's the health care benefits that people can qualify for. Social Security disability is not a means-based benefit. It is you all dependent upon when you've been disabled, and maybe do you have a parent who you can fall under for receiving Social Security. That's not a means-based benefit. If you leave assets to somebody receiving Social Security disability, that is not going to disrupt their benefits. In contrast, there's Social Security income. That is a scenario where, yes, it's a means-based benefit. So you don't want assets allocated to somebody who's receiving Social Security income. On the healthcare side, there's Medicare. Medicare is not a means-based benefit. If you are on Social Security disability for at least 24 months, you can generally qualify for Medicare. And just because you got an inheritance will not disrupt your Medicare. Medicaid, however, is a means-based benefit. Even if you have a beneficiary that you know is receiving Social Security disability and they're receiving Medicare, both of those are not means-based benefits. However, we generally approach this as there's a very good chance that if it's a disabled person, even if they're not receiving means-based benefits now, there's a very good chance that when mom and dad are gone, as this beneficiary ages, there's a good chance that they end up possibly needing Medicaid, and that is a means-based benefit. So even if your beneficiary is not currently receiving means-based benefits, I still recommend you be uber careful in how you leave them money and still implement a wholly discretionary trust for their benefit. Okay, so let's go back to the wholly discretionary trust. What is it? What does it mean? Basically, what we say is, all right, I want to leave my assets to my three children. And child one child 2, and child 3. Child 3 has disabilities. So what we do is we set up a wholly discretionary trust for the benefit of child 3. So child 1 is going to just get their assets. Child 2 is just going to get their assets. Child 3's assets are going to be allocated to this wholly discretionary trust for the benefit of child 3. So we have to make sure that your estate plan is set up so that all assets get allocated to that wholly discretionary trust. It doesn't just happen because your will says it's going to happen. Your will only controls probate assets. You probably have a lot of non-probate assets. For example, a lot of people have IRAs, 401k money. When you die, those are allocated to your beneficiaries through beneficiary designations. They're not controlled by a will. So when I do estate planning with people, if we're going to set up a wholly discretionary trust for a special needs child, we need to make sure that we investigate every type of asset you have and make sure that not only does your will say, I want my assets to go to child 1, child 2, and the wholly discretionary trust for the child 3, you also need to make sure your IRA beneficiaries say 1/3 to child 1, 1/3 to child 2, 1/3 to the wholly discretionary trust established for the benefit of child 3. Life insurance, those are beneficiary designations. We need to make sure that beneficiary is, again, also allocated so that the funds from the life insurance are allocated to that wholly discretionary trust. If assets go to outright to a child with special needs, there's really nothing you can do about it at that point. What you're dealing with at that point is that beneficiary with special needs has to do what's called first party planning. They own the assets, it's theirs. Now, what can we do to still maintain their benefits, even though they receive this inheritance? And there are things that they can do through first party planning. I'm not going to get into that at this point. If we have time, I will get into that. I'm going to stick with the third party planning.
Hey, Anne, there's a question here for you.
Oh, okay. I should put my glasses on.
Nope, you're fine. I'm happy to.
Oh,
grab
you know
them out
what?
of the
I don't
chat
even
here.
see it. So you're going to have to read it to me.
No worries. The question is, what are the differences between a wholly discretionary trust and a special needs trust?
Okay, that's a great question. A great question. Special needs trusts are a very generic term that encompasses a lot of different types of trusts that are set up for special needs beneficiaries. Special needs trusts can be trusts set up for first party planning. Like I just said, the person with the disability already received $100,000 in an inheritance. Okay, the disabled child already received it. What can we do with that 100,000? One of the things you can do is put it in a it's called a D4C pooled trust account. That's a special needs trust. That's a specific type of special needs trust. A wholly discretionary trust is a specific type of special needs trust. The wholly discretionary trust is set up purely for third party planning. And I hope I'm communicating the difference between first party planning and third party planning. Third party planning is, for all you people in the audience, if you have a beneficiary, a child with special needs, You are talking about doing third party planning. You're the third party. You're the one that has the money. What do I do with that money? So a wholly discretionary trust is a trust set up by a third party for the benefit of the individual with the disabilities. So there are some parameters surrounding a wholly discretionary trust that makes it, again, this specific type of special needs trust. The wholly discretionary trust must be irrevocable. The wholly discretionary trust, um, the the has to be set up so that distributions for the benefit of the disabled beneficiary, the disabled child, for instance, the the parameters surrounding distributions are wholly at the discretion of the trustee, whether to what to make, what distributions to make, how much in the distributions to make, and and maybe to not make any distributions at all. So we can't. Oftentimes, if I have somebody in that says, "Okay, you know what? I just have a child that they don't have special needs, but they're spendthrifts. They can't manage their money." Okay, so a lot of times we'll set up a trust for their benefit. It's not a wholly discretionary trust, but it's a trust for their benefit. And the parameters are okay, they can receive distributions from the trust for their health, education, maintenance, and support. Those are discretionary standards that the trustee has to follow in determining whether to make a distribution to that beneficiary. In contrast, the wholly discretionary trust doesn't have any standards. It has to say the distributions are complete and totally at the discretion of the trustee. So, so that is a nice opening for the pros and cons of a wholly discretionary trust. So if you say, all right, there's going to be $100,000 that's going to my disabled child, I don't want it to disrupt their benefits. I'm going to put it in a wholly discretionary trust for their benefit, which is great. That money's going to sit there for the benefit of the disabled child. And it will not disrupt their governmental benefits. However, the distributions, there's no parameters, there's no standards. So the trustee has to determine, okay, when would I make a distribution to them? And for what reason, for what amount, how do I go about doing that? So as you can imagine, you're really, really trusting that this trustee will make good decisions and will make distributions for things that you would want them to be making the distribution for the disabled child. When I meet with a new trustee, so for example, oftentimes, again, we'll say there's the three kids. Child number three has the disabilities. We're going to make child one is going to be the trustee to manage the funds and make distributions for the benefit of this child three. That's a great scenario. Child one comes in, hey, I'm the trustee. How do I go about doing this? And I will advise that trustee on what types of distributions the trustee can make without disrupting the benefits. So even though having the assets in the wholly discretionary trust will not disrupt their benefits, if that trustee kind of screws up and starts making distributions to the beneficiary from the trust for the wrong things, that can screw up the benefits. So we talk to the trustee and we say, okay, look, you don't want to be making distributions from this wholly discretionary trust to cover shelter or food. Their Social Security benefits are meant to cover their shelter and food. So the trust assets should not be making distributions every month for, $500 a month, distribute out to the beneficiary. That's going to turn into income. So are there some things like this that we'll talk through with the trustee to say, hey, wait a second, don't do things this way. Don't pay the beneficiary's rent every month. That's shelter. Don't pay the beneficiary's gas bill every month. That's shelter. Don't be buying gift cards for the grocery store, for Giant Eagle, for the beneficiary. That's food. What you want to use those funds for are the ancillary things. The beneficiary needs a new computer. Use the trust proceeds to purchase a computer for the beneficiary. And interrupt me anytime at this point with questions, because now I'm just kind of rattling along. I got a question, and that's usually how I go. And I think I answered the question.
Another question
I'll
actually
keep
just
going.
popped up. So
Okay, go ahead.
the question is, I was under the impression that a trust cannot be a beneficiary on tax qualified. Janet, was there something else that you were gonna
I kind of think I
finish
know
that?
what they're
Okay.
asking.
Okay. I was under the impression that trust cannot be beneficiary on TQ plans.
Tax qualified plans.
Mhm.
I'm guessing that's what that
Plans.
is.
That was the other
Um,
word that I was missing. Thanks, Janet.
so that's false. That is false. Trust can be the beneficiary, but you want to be very, 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 very careful. Um, Generally speaking, the trust can be the beneficiary, but the trust is not going to enjoy the same tax benefits that an individual would enjoy. So let's go back to my example. I've got 3 kids. The first 2 kids, I'm fine with assets going outright to them. The third child, however, needs to if they receive funds, it's going to disrupt their benefits. So um, we I have the discussion with the client saying, mom and dad saying, okay, if you have 1/3 of your IRA is going to the wholly discretionary trust, it's um, it's not going to enjoy the same tax benefits that the third is, that goes to the individual child. Um, and here's the difference: the individual child will be able to receive those IRA benefits, and they have 10 years to pull the funds out of its identity as an IRA and be taxed on the income as income to that beneficiary. They have 10 years. An individual has 10 years. There's some exceptions to it. A wholly discretionary trust, for instance, only has 5 years to pull it out and pay the income tax. Okay. Generally you say, yeah, that's a bad tax consequence. It's not as good of a tax consequence as what we can otherwise get. But the alternative is disrupt their benefits. 9 times out of 10, we're going to pick to pay more in taxes so that we can still get the benefits. One way around that is, again, if you have 3 kids, maybe you want to say, okay, qualified plan accounts, we're gonna allocate those to my children that can receive assets outright, and I'll allocate non-qualified assets to the wholly discretionary trust. I mean, we can do things like that. Now, having said all of this, there is an exception when a beneficiary has special needs, is disabled. When a beneficiary is disabled, who is the individual beneficiary of a qualified plan account, an IRA. Again, most most beneficiaries, most non-spouse beneficiaries have to pull those funds out within 10 years. A beneficiary with a disability can stretch that over their lifetime. So that's a really nice tax benefit. However, you have to be very careful because, again, being they have to take required minimum distributions, and sometimes those required minimum distributions will be enough income that will disrupt their benefits again. Um, so you really have to think through whether or not that makes sense or not. But back to the main question, um, can the trust be the beneficiary of a qualified plan account? It absolutely can, but you have to be very, very careful in thinking through maybe some unintended consequences of making the trust the beneficiary. Are there more questions?
There are.
Okay.
Janet, thank you. Okay, next question is, what if the beneficiary was living with the trustee? Can the trustee use the funds to help make the home more comfortable for the child now, like add on the home for a new bedroom or something like that?
Um, okay, I see. I think I have this scenario. So let's say the trustee, okay, the trustee is living with the beneficiary. And I'm guessing the trustee owns the house. Um, so could they do add-ons? That's a good question. Um, I'd have to think through that. I believe I believe the answer is yes, but I would have to probably research a few things because I'm not absolutely confident with that. Um, when we really try to to go through like what types of distributions are acceptable from the wholly discretionary trust to that disabled beneficiary. Um, we really say, like I use the computer um, example. There are gym memberships that a disabled beneficiary you could sign them up for gym memberships. Travel, they want to go see their brother that lives in another state, and they so use those funds to cover the travel expenses, and even the travel expenses of a companion if they can't travel alone. That would be an acceptable thing. The other thing I tell trustees is don't give the beneficiary the money to go buy the plane tickets. Buy the plane tickets for the beneficiary. Don't give the money to the beneficiary to go purchase a computer. Go to Best Buy and purchase the computer for the beneficiary. It's much cleaner, it's much easier and smoother. Um, so those are kind of examples of how to use the funds.
So in that situation, she had clarified, she said, the trustee is my sister. My son moves in with her after my death.
Okay. Yeah, I'd have to double check that. Can she um if you really wanted to be safe, what I would recommend doing is allocating some funds to your sister to improve, because the problem is the trust funds are for the benefit of the child. Yeah, I mean, I could see an argument either way, but if you wanted to be on the safe side, maybe allocate some funds to your sister directly to cover the cost of maybe some improvements she would need to make to her house in order to house your child.
Okay. Couple more questions. Let me catch up here. Back in the chat. My wife and I plan to ask the court to award guardianship of our daughter to our son when we are not capable. Can a guardian also be the trustee of the trust, or would it be better to ask someone else?
No, the guardian can most definitely also serve as a trustee. Um, when I talk through the ideal candidate to be your trustee and the ideal candidate to be your guardian um, of the child, ideally, you you in an ideal world, you have that person that you would completely entrust to make medical decisions on behalf of your child, to completely trust in making their living arrangement decisions. You would completely trust in getting them established for everyday activities, and that's the role of the guardian of the person. That's the role of the guardian of the person, and that guardian, you have a person where they will be perfect for that role. Ideally, you would also make them in charge of the funds, in charge of the money that will enable them to provide some of these things that they're setting up for your child. So the ideal candidate is somebody who you would trust to make these decisions for their person as well as financial decisions for your child. Sometimes that's not the same person, though. The person that you would trust implicitly in raising them and caring for them, not raising them, but caring for your child and making life decisions for your child, they may be horrible with finances. That may not be the best person to put in charge as the trustee. So, ideal candidate, they're perfect for both roles. Um, if you don't have that ideal candidate, figure out does make sense to name guardian and who does make sense to name trustee, and make sure those two people get along and can get along. Because you sure as heck don't want a guardian saying, "Yes, I've got all these things set up for the beneficiary, but I can't get along with the trustee enough to work through getting these things paid for." Um, so that's kind of my approach to guardian versus trustee.
Okay. Can a house that is being used by the disabled child, which is owned by the parent, be put into the trust upon death of the parent? And can the child stay in the house without it affecting their benefit?
Yes, absolutely. And that oftentimes is a major part of the planning I do. Um, and a transfer on death affidavit for the house is a great tool so that when mom and dad who own the house both die, the house transfers directly to the trust. It doesn't go to the individual beneficiary, it goes directly to the trust. It avoids probate. It's wonderful. It's a wonderful tool and mechanism to implement this plan. However, as you age, mom and dad, keep in mind that you are the owner of this house, and if mom or dad needs long-term care and maybe long-term care Medicaid benefits, in order to qualify for the long-term care Medicaid benefits, they have to spend down their assets, which would be a house that they own if they're not living in it. So on the one hand, uh, you say, okay, I could be stuck having to sell this house that my special needs child lives in order to pay for my spend down funds to qualify for long-term care or to pay for long-term care. There's an exception when it comes to Medicaid long-term care. You can transfer a house to a child with with a disability who is living in that house. That's an exempt transfer for the parents, and when they're doing their planning to pay for long-term care. The transfer directly to the child is an exempt transfer. However, what you've just done there is created a first party planning situation then. Now the child with the disabilities owns the house outright, not the wholly discretionary trust. So, as you age, here is just kind of not a warning, but like something to be aware of is as mom and dad age, there is planning that you can do if you anticipate needing long-term care, um, and you don't otherwise have the funds to completely private pay yourself, you have plenty of other funds. If you don't have that situation, you may want to transfer the house into the wholly discretionary trust to get through a 5-year look back period for your own long-term care Medicaid planning. Okay. And I don't want to get too much into the weeds of that. The takeaway is if you have this trust, as you age, maybe get some advice about thinking through. Maybe I should transfer it before I pass. Just something to consider. All right. Sounds like there's more questions.
Oh, there is.
Okay.
Okay. Let me just kind of catch up here, make sure I didn't miss any again. Okay, to add to maybe that question, can the trust pay for household expenses?
Not utilities such as electric, gas. I believe it's the core ones. It could pay for cable. It could pay for phone. It just can't pay for like the main utilities for shelter, which are generally water, sewer, gas, electric, those types of things. But if you want to have cable, you want to have internet, you want to have um, um, a phone, yes, it can pay for those household type expenses.
Okay, so let me just jump over to this one since this one sort of goes along with that. What if SSI, Medicaid, Medicare don't completely cover the individual's needs for food and housing? Can trust money then be used without affecting benefits?
You're getting dicey there. So you just kind of want to be creative as much as possible. So if you're otherwise using, I'm just trying to think of examples of um generally speaking, no. The answer is no. I mean, you don't want those trust funds being used to pay for food and shelter because they can cause the SSI to be reduced. It's not going to affect the Medicaid, by the way. It can just cause the SSI to be reduced. Um, I get that you're kind of between a rock and a hard place there, but you're kind of stuck. Sometimes, for instance, we have made distributions out of the wholly discretionary trust to the beneficiary. And then we did first party planning and said, okay, put these funds into a stable account. And the stable account, you can use those funds they're much more flexible and you can use them for food and shelter. So maybe you get creative in that way and you say, okay, well, I've got 100,000 sitting in this wholly discretionary trust. Maybe I'm going to distribute 10,000 out to the beneficiary, and that beneficiary is going to plop that into a stable account and then use the stable funds to pay for some of that food and shelter that isn't otherwise covered by SSI.
Okay. Okay, next one is it good or bad to put a timeshare in the trust name?
Timeshares. most estate planning attorneys, when we hear those words, we say, oh, yuck, yuck, yuck. Um, Timeshares can just be so restrictive. It all depends on what the timeshare agreement allows. Um, it is, you really just have to work with your timeshare company. Um, but I don't know if you ever hear those commercials. Can't get rid of your timeshare? Call this 1-800 number. We can help you. I mean, they have actual companies set up to help people get rid of their timeshares because it's can be such a pain and so restrictive. So I cannot give you a definitive answer to that question right now, but what I can tell you is you go talk to the timeshare company and determine the parameters now. Don't wait and um, let that happen during post-death administration because it's a nightmare. It's a nightmare.
Can you assign multiple trustees?
Absolutely. Just be careful. If you have two, you can really be stymied. One is good. Three is good. Five, you're getting, it could be very cumbersome. Um, but the reasoning being, the trustee decisions, you want to be able to have majority rules. So if you have two, you can't do majority rules. Um, you can do two and say either one can have complete and total power. Um, it can be either or. Child one or child two can be my co-trustees, and either one can make independent decisions on their own behalf. For a convenience matter, if you have two, or more than one, from a convenience standpoint, that's very nice and it's helpful for the trustees, unless those trustees don't get along and you've got one that's maybe going to go rogue and do something off on their own, without consulting the other one. Um, so then the alternative is let's have three so that there can be a mechanism for a majority decision on, and not any one can act on their own. They two out of three have to agree, but then you're trading off ease of administration there. You are making it more cumbersome for the trustees to actually get things done. If you have the ideal candidate, I say just do one. And then have other people as a succession if that one wants to resign or that one can no longer serve for whatever reason. Then you have a succession of people.
Can the house be sold out of the trust for any reason if the beneficiary can't live there anymore due to their health, possibly?
Absolutely. And the trustee will be the one to sell it. So the trustee sells it, and now the trust holds a bank account with the sale proceeds from the sale of the house. And then now you have funds that you're using.
You mentioned person with a disability. Who determines if a person is disabled?
So generally, that's through Social Security Administration. Oftentimes, in order to get any of these benefits, you have to be deemed disabled by the Social Security Administration. Now, having said that, I mean, there are, some clients will set up these wholly discretionary trusts. I mean, and the concept that I'm expressing tonight is, because of the audience, we are assuming it's children with the disabilities, and they are receiving these governmental benefits, and we don't want to disrupt the governmental benefits. Having said that, I've also set up these trusts for people who say, look, my child three is functioning, they're fine, they're working on their own, they're not on governmental benefits, but I just wouldn't trust them with any money. And there could be a chance that they need benefits in the future. So let's be safe now and put it in a wholly discretionary trust, even though they're not actually receiving governmental benefits yet, and they haven't been deemed disabled at this point.
I think we are caught up on questions.
Okay. Okay. What time is it? Because I'll kind
We
of
are
decide.
10 to
Oh,
7.
10 to 7. Okay. Um, I always like to convey in these, if we do some first party, switch to first party planning, meaning what kind of planning can the actual individual with the disabilities do? What are they able to do? I always, always, always want to impress upon everybody that um, individuals can have disabilities, and it doesn't mean they automatically need a guardian. Um, they may be high functioning people with disabilities, and they ha- can very well have the capacity level necessary to appoint a financial power of attorney on their behalf and a healthcare power of attorney on their behalf. And if they have those two roles filled, they don't need a guardianship. So don't always just jump to guardianship right off the bat. It's supposed to be a means of last resort. Um, I oftentimes meet with the the adult child with disabilities, and we go through, kind of, I call it a capacity assessment. I don't have the ability to assess their health capacity. I know what the law requires that they be able to know and understand in order to execute these different documents. So I will go through a process of asking them questions and talking with them and kind of getting a feel for it. And if I think, yeah, you know what? I think they do understand the nature and effect of what this power of attorney does. I'll have them execute one. Um, Keep in mind that um, powers of attorney are excellent ways to avoid a guardianship, but powers of attorney do not prevent the individual from being able to make their own decisions. So just because they've appointed somebody as their financial power of attorney, they've now given somebody else the ability to make financial decisions on their behalf, but they haven't relinquished their own ability to make the financial decisions. So, um, so that can be a deciding factor between should we get the guardianship or not, is do we want to be able to prevent the child from making bad decisions, and they seem to go rogue, and okay, then maybe you need the guardianship.
Okay, we got
Did I
one more.
see questions?
Yes, we have one more question come in. Can two disabled children be included in one trust, or should there be separate trusts?
Separate trusts. And it's pretty easy to separate the trusts. Oftentimes you may need to submit the trust to Social Security, and it just makes it cumbersome when there's more than one child. There's also, it's called, you may hear the sole benefit rule. So in order for it to be exempt, it has to be for the sole benefit of the child with disabilities. Can't be shared. So we separate those if you have two disabled children.
Okay. No more questions right now.
Okay. I think we're nearing the end anyway, so.
Okay. Yeah. Is there anything else, Anne, that you wanted to add, or do you want me to wrap up and see if anyone has any more questions while I'm
Yeah, I would say wrap up.
chatting?
Yeah, hopefully, you know, I I mean, I could go on forever. But I always, like I said, I find that answering specific questions is a lot more beneficial and engaging. Um, I have my PowerPoint that I could go through, but it's just really boring that you're stuck with. So,
All right. Oh, people are saying thank you. I appreciate it. So I want to extend a big thank you to Anne for taking time out of your schedule to present for us this evening. I also want to thank everybody who took the time to attend tonight. You will be receiving a follow-up email, hopefully tomorrow, from MCBDD. Now, those get generated through constant contact, so please be sure to check your junk or spam email. That will have a copy of the recording of the presentation, so you can go back, rewatch whatever you need. And that will also have a survey link. So if you could take the time, we would greatly appreciate your feedback. This kind of helps drive future trainings and presentations that are offered here. And then since we kind of have a parent audience now, I will just mention too that applications for our Leadership Academy are going to be opening on January 26th. It's a 6-month training opportunity for people with developmental disabilities to learn, further develop leadership skills, take a more active role in the community for whatever that looks like for folks. So each class has a different topic. The class runs from April through September. We have one class a month. It's like a 2-hour commitment a month with a little bit of time out of class. So if you have a child, an adult child, or know somebody who would like to participate, please feel free to reach out to me. The information's on our website as well, but there will be more coming out within the coming weeks on that. Let me just check and make sure we don't have any questions while I was going on. Okay. All right. I think that's it.
okay. Thank you,
So
everyone.
thank you. Thank you, Anne.
Have a good
Have a
night.
great evening, everyone. Bye-bye.